Sir, I take the opportunity at this moment requesting our chairman, Justice Manmohan, to give his address to us.
Respected Justice Call, Acting Chief Justice, Justice Vipin Sanghi, Justice Shakdar, Justice Sanjeev Sachdeva, Justice Naveen Chawla, they're all members of the committee. Justice Sudhir Jain, who's actually the domain expert in the committee with regard to mediation. Brother and sister judges, organizers, court staff, dear friends. When we were planning this event, the unanimous view was that Justice Kaul must inaugurate the event. In fact, it was during his tenure as Chairman Samadhan that the mediation made giant strides. So Ms. Beena Rali and Mr. J.P. Singh, I think, contacted his staff informally to find out whether he is available or not on this particular day. And we were told that he was already preoccupied. He had to release a book for a lawyer who also happened to be a mediator. So once this issue was raised, they came to me and said, resolve this. So we decided to use our mediation skill. So we called the lawyer, who happened to be a friend, and we said that, you know, you'll have to spare Justice Kaul for us. And he was kind enough. So after some mediation, he agreed. So it worked. So welcome, Justice Kaul. I'm glad you are here. The word acting actually defines Justice Sanghi. See the alacrity with which he's taking administrative decisions, the way he's forcing all of us to complete infrastructural projects, the way he's asking us to hold seminars is really taxing, but he's performing according to the correct expression, which is acting. So we welcome Justice Sanghi also. See, as far as mediation is concerned, I must say it has come a long way. When I joined the bench, it was an alternative dispute resolution mechanism. Today, I think it is the most appropriate dispute resolution mechanism. And in fact, it's the first choice of resolving disputes. Mediation is in fact not just a tool of resolving disputes. It's something more. It's like a life skill. It helps you become a better human being. See, it helps in healing, in transforming relationships. Most of the time in commercial matters, when there is a dispute, you have a dispute with a stranger. You settle with him and you may never see him again. But there are a large number of litigations which are involved with immediate family members, with immediate neighbors, with your colleagues with whom you work on a daily basis. When you have these disputes, you can neither change your neighbor nor your family. So therefore, mediation becomes a very appropriate mechanism to settle these sort of disputes. See, it helps you to heal. It helps you to transform. For instance, I have wondered, when 5 brothers are fighting in a partition suit, how do they celebrate marriages? How do they participate in each other's functions? After all, whom do you call for your marriage or for a celebration if you can't call your immediate family members? So these are disputes where you require the most appropriate mechanism to resolve it without ensuring that there is further aggravation of the dispute. So therefore, according to me, it's the most appropriate way to resolve matters in certain situations. In fact, my experience as a judge has been that mediation has been able to resolve a number of family disputes, a number of matrimonial disputes which had been pending for decades. Even if a judge had devoted reasonable time to those disputes and resolved them, they would have only moved from a single judge to a division bench. They would not have been fully and finally resolved. The biggest achievement of mediation is that it fully, finally, and conclusively resolves the dispute. Therefore, it is of utmost importance that this momentum or this movement must gain further momentum. Now, in mediation, in litigation, what one also finds is that there is a large number of innocent third parties which are involved. For instance, in a matrimonial dispute or in a child custody dispute, there is a child who is involved. Now, the child has now become a weapon in the hands of either the wife or the husband. And I have in one case seen that the child realized that he is being used as a bargaining chip. So he decided, why should he not bargain? And I found that he ultimately decided to bargain and wanted to get the better facilities from either the father or the mother. So it is very, very complicated. There are innocent third parties that are involved. So therefore, at times it is very much necessary to get an immediate resolution of the dispute. And this happens in mediation, to my mind. And mediation helps resolve the acrimony. I think Veena used a correct expression. There is too much acrimony in the society today. In fact, when you sit as a judge on the criminal side or on the civil side, you realize how acrimonious our society has become. No one is willing to cede, no one is willing to see reason. And mediation helps you grow. Grow in the sense, when you make a concession, you are actually growing in your life. You know, mediation has now become a way of life. Therefore, it's very important that this appropriate dispute resolution mechanism is pushed further ahead. Our mediation center has been working very well. It's made giant strides. But if you were to ask me, is that good enough? Should we stop? The answer is definitely no. We must make further progress. Mediation, to my mind, is a science as well as an art. If someone thinks he can be a good mediator because he's a patient listener or he's worldly wise, then I think he's mistaken. In fact, there are certain formulas, there are certain techniques which you must know. If you don't know them, you will not be a good mediator. You will not know how to handle intricate situations. So, according to me, a mediator is like a scientist or like a doctor. So he must be well equipped, he must know the theorems, the formulas, how to deal with different situations. You are blessed that you have very good teachers who will be teaching you. I have attended a few sessions. When Justice Kaul was the chairman, he insisted that we all come, and we participated in a few sessions. And these teachers, they make it entertaining. They don't give sermons, as it were. They don't teach you, or their teachings are not in your face. They do it in a very subtle manner. It's done with a lot of finesse. And it's done in a participatory process, where you participate in the discussions, where you will say what you have gone through, and they will then say how it could have been done better or what are the techniques and formula that could have been employed. So you're blessed that you have such good trainers. There is also an important aspect which you must understand. That is, the mediator is the most important person in this dispute resolution mechanism. Everything hinges on the mediator. how he advises, how he wants to proceed ahead, how much confidence he can get of the two clients, how much confidence he can give to the parties, and he must ensure a fair settlement. See, the other day we did a short seminar, I think Justice Sudhir Jain was there and Justice Swaran Kanta was there, on labor matters. And there one of the concerns flagged was, for instance, I think he should advise them that this is not the way we should settle, or these are not the terms on which we should settle. So quality of settlement is of utmost importance. Especially now the focus is shifting from just personal matters to commercial matters also now. In fact, the new bill after the Singapore Convention is laying a lot of emphasis on commercial disputes and resolution of the commercial disputes. So the quality of mediation, the quality of the mediator is going to be of utmost importance. So please concentrate hard on what are the techniques that are being taught. Please imbibe them, because as I said, the most important person in that room is the mediator. If you know all the techniques and the formulas, you will be a good scientist, a good doctor, and you will be able to resolve many more matters, and your quality of dispute resolution will be very good. I want to say on part of our judicial system that we repose a lot of faith in mediation. The fact that today we have about 15, 16 judges who have come all the way to participate in your conference shows how much importance we attach to this moment. We are getting good assistance. We are very happy. We want to push it a little further. I realize that there are certain no-go areas at the moment, as they were called, for mediation or for settlement. Like IPR disputes is a problem in the sense because it binds only the parties to the dispute and not third parties. So there are some constraints in that area. But I feel ultimately there are commercial disputes at heart, and somehow the boundary will be pushed in the years to come. In fact, I see mediation as a sunrise jurisdiction. I will not be surprised if the mediators shortly or in the near future start making more money than the arbitrators. So it is a lucrative field. I see great future in it. Please go through your training in an earnest manner. Imbibe the principles that are taught to you. Learn it and implement it. I wish you all the best, and we hope that it's mutually a beneficial exercise for both the bar and the bench. Thank you very much.